Hi, welcome back. Now that we have discussed 3 out of the 4 components of a contract, we will discuss the last and the final component, which will be intention to be legally bound. Let's explore. When we discuss on the intention, say there are two parties who are involved in discussions to have an engagement and then a subsequent contract. Both these parties should have the intention to be legally bound, and that respective contract should be within the country's legal framework. And whenever there is a dispute, that contract could be taken to courts for discussions. So, having the intention of being legally bound is very important when two parties enter into a contract. When determining whether the parties intend their agreement to be legally binding, the courts are guided by two basic presumptions. And they are: the first one, parties to a social or domestic agreement do not intend to be legally bound. And the second one would be, parties to a business or commercial agreement do intend to be legal bound. Presumption 1. Social or domestic agreements. The courts believe that any family or friends do not generally intend agreements to be legally enforceable unless there is a clear evidence of a commercial transaction. So, mostly when a commercial transaction is unavailable, and if the agreement is between family and friends, then legally it's assumed that they don't have the intention to enforce anything at courts. Example, another example from the UK court history. No intention to create legal relations existed. An agreement under which a husband working in Ceylon promised to pay £30 a month maintenance to his wife in England. So there was no intention of enforcing anything because the agreement or the arrangement was between a husband and a wife. Then we move on to the second presumption, business commercial agreements. The courts will always assume an intention to be legally bound in all business and commercial agreements. So as we discussed in the previous one, if there is any commercial business intention agreement, then the court assumes that there is an intention to be legally bound. Trading puffs. In today's business world, we see a lot of promotional activities and promises given by sellers to the buyers. So, during these promotional promises, the buyer should be very careful because these promises will not be assumed to be legally binding. Example, Red Bull gives you wings. That's a statement that is shown in Red Bull promotional activities. But in actual terms, you cannot have wings after having Red Bulls. So you can't legally enforce something against Red Bull because of this statement. And then the consumers are expected to be able to differentiate between fact and fiction. And there could be specific promises may, however, to be assumed to be legally binding. Example, lowest price guaranteed or will refund the difference. So these sort of statements could be legally binding and sometimes could be taken to court for discussions. So when you talk about this intention to be legally bound, the moral or the advice or the summary would be, beware mixing business with pleasure. Do not confuse business with pleasure. Make it clear if an agreement is business or pleasure. Business partners and Co-workers are not your friends, but they will have high expectations and will usually be able to hold you to what you have agreed. Do not agree to business agreements or arrangements that you do not intend or cannot keep. Family and friends are not business partners, and you can't usually hold them to what they agreed, or even if you can, it may come at a high personal price. Now we will be moving into the final section of this session 9, which will be legal rights, duties, and obligations. So, what do you mean by a legal contract? A contract is a legally binding agreement between two or more parties. So it could be between two individuals or it could be even between two organizations. These contracts are made orally or in writing, and it will act as an issue of proof. But we should keep in mind that all agreements are not legally binding. There could be social or domestic agreements, which we discussed in our previous slides. Or there could be contracts or agreements with minors who are children under the age of 18. So these two categories will not be legally bound. So when you say social and domestic agreements, as we discussed in our previous slides, those are agreements between friends, families, or in social settings that are presumed not to create any legal relations, but it will be an engagement level agreement. Any contract with a child under the age of 18 is not enforceable against them unless it is for any basic necessaries or is a beneficial contract of service, such as a contract of employment or education, where the contract as a whole is for the benefit of these children. So why are contracts necessary in an industry? As professionals, we should understand our rights and responsibilities. And when two parties, individuals or organizations, enter into an agreement or engagement, this contract will include all these rights and responsibilities, and that it will be within a legal framework. So any dispute, this contract could be taken to court for discussions. So all these business transactions will have financial risk. So why contracts are needed? Because to make sure that any disputes can be resolved, and on top of that, the professionals will be able to understand their rights and responsibilities, and the particular financial risk takers will be rewarded based on these responsibilities. Example: Martin Smith versus Williams. So Nigel Martin Smith was the manager of the group take that at the time Robbie Williams left. Robbie Williams was the managing director of the organization. Nigel Smith sued Williams for unpaid commission. Williams claimed that Martin Smith breached his duty to him when he was sacked from the group. Held, the court did not accept that Martin Smith had breached his duty to Williams, and Williams was in breach of a contractual promise in his management agreement to pay commission to his ex-manager and was ordered to pay £90,000 of damages. So when it comes to contracts, there could be so many contracts that could be seen in the business world. And those contracts would be between employers and employees, businesses and suppliers, businesses and contractors, businesses and businesses, businesses and individuals, and individuals and businesses. So when it comes to business affairs contractors or contracts, I would say, there could be so many other parties who will be assisting the respective stakeholders in defining and putting these contracts into action. So lawyers would be one set of people who are interested in such contracts, because lawyers are involved in direct negotiations of contractual agreements and they provide legal advice. Also, there could be people like accountants, financial advisors, who could give their respective expertise in terms of tax liability, recovery of income, investments, pensions, disputes, audits, so on and so forth. So they will have a contract of service as an employee or a contract of services as an independent contractor. Now that we have come to the end of the session, let's recap what we have learned in this session. There are four basic components in a contract, and they are an offer, an acceptance, a consideration, and an intention. In order to have a valid offer, there needs to be three requirements, and they are a clearly stated terms and conditions, intention to do business, and communication to the offeree. There are 6 basic ways of terminating a contract. To be legally binding, an acceptance must fulfill 3 rules, and they will be: it must be a mirror image of the offer, the acceptance must be firm, and must be communicated to the offerer. There are 5 rules governing any consideration, and they are: it must not be in the past, it must move from the promisee, it must be sufficient, it must not be something the promisee is already bound to do, and it must be legal. When determining whether the parties intend their agreement to be legally binding, the courts are guided by 2 presumptions, and they will be: parties to a social or domestic agreement do not intend to be legally bound, and parties to a business commercial agreement do intend to be legally bound. And then, not all contracts are legally binding, especially the ones social and domestic agreements and contract with minors. I have provided more details in the PDF document. Please go through them. Hope you have enjoyed this legal and the contract session. Thank you very much.